Hello everyone, my name is Vaishnavi Parate. I am a human rights activist at All India Human Rights Association, and today we are going to discuss and learn about kinds of punishments under IPC, that is Indian Penal Code. So let's start. Let's start with the introduction. The primary object of government is to punish the wrongdoer and to maintain law and order in society. Punishment is the penalty for the transgression of the law. It is the state that punishes the criminal because we know that crime is a public wrong that affects the whole society. Punishment implies some kind of pain inflicted upon the offender for his criminal act. It may be intended to deter him from repeating such a crime or may be an expression of social disapproval for his antisocial conduct. Now let's see what is the meaning of punishment. Punishment is any damage or pain inflicted on an offender through judicial procedure. It is a process by which the state inflicts some pain on the person or property of a person who is found guilty of the crime. In other words, punishment is the sanction imposed on an accused for infringement of the established rules. The term punishment means torture that a person should undergo an account for doing wrong. It is deliberately imposed on that individual without his consent and against his will. Now let's see some definitions and object. According to Hobbes, punishment is for the transgression of rules and it is inflicted by legally authorized persons. According to Hall, punishment is a coercive deprivation intimately applied to an offender because of his voluntary commission of harm forbidden by penal law and implying his moral capacity. As per Bentham, punishment is an empirical question of desire and the infliction of sufficient pain to provide an effective deterrent. The object of punishment is to protect society from disobedient and undesirable elements by deterring potential offenders, preventing the actual offenders from committing further offenses, and reforming and turning them into law abiding citizens. Now let's see kinds of punishment. Chapter 3 of the Indian Penal Code 1860 defines different punishments for various offences. Section 53 of the IPC enumerates the different punishments that the courts may award to a person convicted of a crime. The punishments to which offenders are liable under the provisions of IPC are firstly, death, secondly, imprisonment for life, thirdly, imprisonment which is of two kinds, namely rigorous and simple, fourthly, forfeiture of property, fifthly, fine. Now let's learn about this punishment in detail one by one. Death. The death sentence is a punishment that is sanctioned by the government and ordered by the court where a person is put to death for a crime acted by him. In earlier times, sentencing offenders to death was a very common kind of punishment, even for minor offenses. In modern times, death sentences have always been used as an effective punishment for murderers and dangerous offenders. It has both a deterrent and a preventive effect. Some countries abolished it. Capital punishment, death penalty is awarded in India in certain exceptional cases only. Imprisonment for life. Imprisonment is defined as the deprivation of the liberty of another without his consent. Life imprisonment means a sentence of imprisonment running throughout the remaining period of the convict's natural life till death. But in practice, it is not so. In practice, it is 14 years and 20 years under Section 57 of IPC. Section 55 empowers the appropriate government to commute the period of life imprisonment. It was substituted for imprisonment for life, is to be treated as rigorous imprisonment for life. Rigorous and simple imprisonment. In case of rigorous imprisonment, the offender is put into hard labor such as grinding corn, digging the earth, drawing water, cutting firewood, mowing grass, etc. IPC prescribes this punishment for offences includes personating a public servant, section 170, causing miscarriage, section 312. Simple imprisonment is imposed for small offences like wrongful restraint, defamation, etc. In such cases, the offender is confined to jail and is not put to any work. Some offences punishable with this includes refusing to take an oath, section 178, defamation, section 500. Forfeiture of property. Forfeiture of property means taking away the property of criminals by the state as punishment. The punishment of absolute forfeiture of all property of offenders is now abolished. It is imposed for the following offences: committing depredation on territories of power at peace with the Government of India, section 126; receiving property taken by war or depredation, section 127; the property purchased or bid by a public servant unlawfully, section 169. Fine. Fine is derived from finis and is so called because its payment puts an end to the offence for which it is imposed. It is a pecuniary punishment. IPC prescribes fine as penalty, both independent and along with other penalties. The amount of fine varies with offences. It is at the discretion of the court as to whether either imprisonment or fine or both are to be awarded in a particular case. Fine is the only punishment for some offences, including false statement in connection with the election, section 171G, failure to keep election accounts, section 171I, illegal payments in connection with the election, section 171H, C.